Welcome back to the Emily Show. It is Monday. That means it's time to break down what's going on in the law in a semi-quick fashion. I truly do intend for this episode to be a summary, but sometimes I just get to talking and then we keep talking. It just is really the nature of things on a podcast. So if you are watching on the YouTubes, remember that all the topics are timestamped down below. Today, there are a bunch of them because we have a hearing pending for tomorrow, Tuesday. Well, tomorrow, if you're watching this the day it's released, tomorrow, Tuesday, February 25th, 2025, for a continued hearing in the Karen Read case. I'm going to talk a bit about what is expected at that hearing, what we know, what the court's order says, where the defense motion to dismiss is, and more. So we've got to talk about the Karen Read case ahead of that hearing Tuesday, and then what will come in the next month or two ahead of the April trial date, because there is a lot of litigation that will happen between now and April. We have some major rulings in the Idaho case. The prosecution of Bryan Kohberger still scheduled to go forward to trial in August of this year through November of this year. That is going to be a substantial and lengthy trial. There are also some surprising Diddy updates, not as surprising as last week's dismissal against Jay-Z, but a very surprising motion by one of his defense attorneys who's asking to be relieved. We're going to take a look at that filing. And then a ton is happening in the Lively Baldoni Wayfarer litigation saga. I'm going to do an overview of what's been filed, touch on a couple points from what's been filed, but we need to do a deep dive on now the two first amended complaints that we have and what they say, what this motion to dismiss an anti-SLAPP motion is, and what litigation I expect, because there's going to be a lot of litigation to come, and the attorneys have filed that stipulated protective order, but then a request for even more protection. So lots to get into, and we should just get into it. I'm legal analyst Emily D. Baker. This is the Quick Bits, where I break down just the main points of the pop culture and entertainment cases I'm currently covering on YouTube and the Emily Show podcast. Let's get into it. Starting with the Karen Read case. This case was in court last week on Tuesday and then came to an abrupt halt, and those videos will be linked down below if you want to see the entire hearing. That was almost 2 hours in length, or if you want to see the quick bits of that, they are down below. They're also on the Emily Show podcast if you listen to that on your favorite podcast player. But if you have the Lawnerd app at lawnerd.com, then you can just click the watch now, because those get sent to you in your app every single time they drop. So you're always in the loop with the cases that you want to see coverage on the most. And right now, the law nerds are deeply invested in what's going on in this case ahead of the retrial. And I get it, because I am too. We've had the Supreme Judicial Court ruling. We have this case with a habeas petition that's going to be heard in early March. And then we have this continued hearing after the judge took an abrupt pause, stormed off the bench, came back in, visibly still upset, and continued the hearing until this Tuesday, February 25th. I wanted to go back through what happened in the hearing before, because I wanted to just hit what motions had been ruled on, because by the time we got to the judge taking off the bench, it kind of, well, overwhelms the rest of what happened in the hearing and then what is left. But there are still motions left that weren't decided, that should have been, that weren't even heard yet. And so we have one substantive motion, well, one plus substantive motion left to go. So at that hearing, before the judge left the bench and the hearing was continued, they got through quite a bit of litigation. The court had gone through quickly a Commonwealth Records request from a media outlet. The media outlet agreed to turn over the items that were requested. That is related to an interview with Boston 25 and Ted Daniels of Karen Read. And now that I'm seeing that there is another Karen Read, it looks like an investigation discovery multi-part series dropping ahead of the trial. I'm sure we'll see another motion about this, because we know the Commonwealth wants all of the unaired footage and all of the, raw and uncut interview and the rest of it. And I think we'll see those coming up in the second trial. And so that was quickly resolved. We also had the motion from the defense to produce a, quote, forensically sound copy of the videos that have been much fought over, not only when they sprung up during the first trial, but since then, because new video has continued to be turned over since the first trial, which all should have been turned over before the first trial, because it was all produced in 2022 when things happened. So from 2022 to 2024, the videos didn't get turned over. And even after the first trial, they were still turning over new things. They wanted it with the metadata. The Commonwealth pretty clearly said on the record, we don't know if we can turn over what they're asking for. It seems pretty clear that the metadata from the police department DVR system is gone at this point, but perhaps metadata exists from when those videos got saved, whatever hard drive they're saved on. And the Commonwealth's special prosecutor, Hank Brennan, was saying when we click and paste or click and copy, we don't know what metadata is there. It's like, okay, well, ask someone who might have a bit more forensic background if they can copy that information instead of you just copying, clicking a video and turning it over, perhaps. But the Commonwealth did say at the very end of that portion of the hearing that they are asking for things I don't think we can accommodate. So it seems that there is still going to be an ongoing fight over the metadata, but that's under advisement. There was a motion for pro hoc vice regarding another lawyer that the defense wants to bring on to the defense team. And the Commonwealth said, we're not objecting, but we'd like to give a bunch of information to the court. The court asked the defense for an affidavit regarding this. That's not been filed yet. So we will see what the court does with regard to another pro hoc vice attorney, Mark Betterow. These are often just routinely granted, but we've also seen the court in this case ask for affidavits regarding attorneys that are coming into the case. We also saw the modification to a protective order regarding information turned over by Gretchen Voss to allow the Commonwealth to have it transcribed. That's not unusual, but it is asking the court for an exception because if it's attorney's eyes only, that means the attorneys. That does not mean and someone working with the attorneys to prep the case. So I appreciate the carefulness in asking for that modification, a carefulness that didn't extend through the rest of the hearing. The motion for discovery from the defense with regard to the victim's car, the defendant's car, and the driveway at One Meadows Ave was also, well, not really ruled on because it seemed to resolve because the Commonwealth turned over a 3D scan recently to the defense. It seems that that 3D scan is coming from the Commonwealth's new accident reconstruction expert. So the defense said this 3D scan should be sufficient for our expert. And if it's not, we'll readdress this. So that motion is essentially paused until the defense needs to relitigate it if that 3D scan is insufficient for their expert. But if the prosecution's new accident reconstruction expert did this in the industry standard, that 3D scan should be sufficient. And we're going to see 3D scans, it seems, at the next trial and much more conversation about whether or not Karen Reed's taillight was damaged by bumping into John O'Keefe's car when she was backing out of the driveway. Then there were several motions regarding discovery. Those are taken under advisement, and we will see what happens with those items of discovery. And that's when we got into the ARCCA motions, which is where the hearing went off the rails and all got shut down. But we didn't get to the end of that. We were really just at the very beginning because we haven't heard the response from the defense yet. And that ARCCA motion is regarding the experts who were again hired by the federal government and whether or not the defense has discovery to turn over to them. And if the defense is prepping with these witnesses now, there likely is discovery to be turned over, but we're not at the defense discovery deadline just yet. So it's going to be interesting to see how the timeline of this shakes out on Tuesday, because the timeline of what and when the defense was communicating with these experts during the first trial vis-a-vis now is going to really matter. And the timing of that matters, and who turned over what information clearly matters to the court, whether the federal government turned it over, and some has been turned over by the federal government, and then what the defense turned over when and what period of time it relates to. I expect we're going to hear this very thoroughly discussed on Tuesday because the court made clear in the order to appear that this is the main topic, and we're going to get to that document in just one second. The other motion that is still pending is a defense motion to exclude the Commonwealth's expert that seems to be the expert they're offering regarding John O'Keefe's arm. Remember, the defense has their doctor expert who is saying those injuries came from a dog bite, not from a vehicle. And remember, during the first trial, the judge very clearly ruled that if you are going to testify about medical causation of injury in Massachusetts, you must be a doctor, and kept the ARCCA experts from testifying about cause of injury, even though it was in their realm of expertise. It was not a medical realm of expertise. And this is one of the things that will differ between jurisdictions, because we saw biomedical and biomechanical engineers testify about injury and cause of injury in the Gwyneth Paltrow case in Utah. but jurisdictions do vary. And the judge said in Massachusetts, medical cause of injury, medical doctor. Well, the Commonwealth's proffered expert is not a medical doctor. And I was very much looking forward to hearing how that was going to shake out, because it seems that the court can't really backtrack on that ruling because it seems to be the law of the land. And that was what Attorney Alessi had come in for. He is the one handling the experts. He had come down from New York to Massachusetts. Emily, down, up, I don't know, wherever in relation the two states are on the East Coast. He had traveled from New York to Boston for that hearing. And at the end of the hearing, you see Attorney Yannetti say to the judge, can we hear Mr. Alessi's motion, which seemed to be considerate of Alessi's time? And the court said, no, we're done here for today. So we should get to that hearing as well on Tuesday. I don't even think the court is going to grant a Daubert hearing like we saw with Dr. Russell for that, because, well, the ruling seems to be pretty clear. Medical cause of injury, medical doctor, and the Commonwealth's expert isn't. So let's look at what the court said that she expects to be addressed on Tuesday. This was filed by the court as a notice to appear for continued hearing on February 20th and says, on February 25th at 11 a.m., the court will reconvene the hearing that begun on February 18th, 2025. Counsel should be prepared to address issues related to defendant's recent production pursuant to Rule 14, especially as the materials produced relate to prior representations made to the court on the record by defense counsel concerning the ARCCA witnesses. Let's break that down real quick. The court is clear now that the defense produced those records, even though on the record, Brennan initially made much of those records coming from the federal government pursuant to a TUI request. He said very briefly, the emails that I had read to the court were produced by the defense, not the federal government. So the court now seems very clear that these are from the defense and said counsel should be prepared to address issues related to defendant's production. So those are the emails that they were talking about in court. And we see that the court is frustrated because the question is about materials as they relate to prior representations made to the court on the record by defense counsel concerning the ARCCA witnesses. So let's take a look at just a little bit of the beginning of day 22 of the Karen Read trial on June 10th, 2024, where the Commonwealth brought to the court's attention that they were having concerns about reciprocal discovery from the defense, and they wanted to make sure that they were provided with everything regarding not just Dr. Russell, but others. And then the court moves to the ARCCA experts, or ARCCA, who were hired as part of the federal investigation in this case in the federal grand jury, the results of which we still haven't seen yet.
All right. Now, regarding the three experts from ARCCA. So I've read that report. I can't tell who does what or what the basis of their opinion is. So what have you provided?
Your Honor, we've provided everything that we know. We've mentioned to this court at sidebar, these experts did not arise from us.
I understand that.
These experts were hired by the federal government, and they provided a report to us pursuant to the TUI request, and it was specifically outlined that and ruled that they could not prep with us for trial.
So I'm to believe that the defense is calling three witnesses that you've never spoken to and putting them on the stand here
that's essentially it. We've spoken to them only for the purposes of coordination of their testimony and their background. That's it.
And this, we're going to let Yannetti continue, but this is going to be one of the central things we're going to hear about on Tuesday. We saw the prosecutor last week quoting this part of the transcript, and Yannetti saying that's essentially it. We've coordinated with them. Well, when did that coordination change, or did it change? Or did it change ahead of the second trial? Or did it change between the day they did the voir dire and the trial testimony? So we're going to let Yannetti continue, but the court said, I'm to believe you're calling experts you've never spoken to. And Yannetti says essentially, yes, we've coordinated with them, but that's it.
We have not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have.
See, I don't see that as being, the report, I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify to.
Well,
and you have not complied with your Rule 14 obligations.
We can't, Your Honor. We can't.
So you can't.
And we're going to end up back in the you haven't complied with your discovery obligations. We can't from the Commonwealth as well. The difference with the Commonwealth, though, is that they were in control of the data that they're now saying they can't produce, where the defense here wasn't in control of these experts because they were not hired at this point by the defense. They may have since been hired by the defense, but they weren't during the first trial.
But you haven't. So I am left with you haven't complied. So we need to get everybody here for voir dire. They can testify in a voir dire, right?
Yes.
We need to do.
And we know that that's what they did. The court brought them in. There was a full day of voir dire, and then they testified at trial. But that colloquy with the court between Mr. Yannetti and the judge is going to be central to what we see on Tuesday. Let's now talk real quick about the upcoming trial of Sean Diddy Combs, because there has been a lot of litigation and there's a lot to go, including a motion to dismiss count 3 of the indictment. The government hasn't responded to that yet, and when they do, I will cover both motions together. We also have a request again for a bill of particulars wherein the defense is saying we need more information about the victims and witnesses in this case. The date for that to be turned over by the government is not due until March 21st, and the government is objecting to turning that over any sooner, saying in their continued objection that particularly in this case, advanced turning over of the names of victims and witnesses can lead to them being harassed, threatened, and otherwise contacted, and that that's a concern here. So they are still asking the court to hold to the scheduled dates ahead of trial. And the defense is saying, look, the government's turned over 20 terabytes of data. And if we don't have the names of the individuals to at least start to search through that, we are not going to be ready for trial. And we are starting to see that in motions where the defense is starting to say, this is hindering our ability to prepare for trial to start at the beginning of May. I still think this trial is likely going to get pushed back from May because the defense is just not going to have enough time to get ready because of all the information and the complexity of this case, because of that Ricco allegation. The Ricco allegation opens the door to go back decades into information that's not charged independently as a crime, but as a basis for that ongoing organization. So I'm not surprised it's over 20 terabytes of information. What I am surprised about, however, is this motion from one of Diddy's defense attorneys saying that he is leaving the defense team, but it's how he said it that caught my interest. This was filed on February 20th from defense attorney Anthony Ricco. This is one of Diddy's numerous defense attorneys and is asking the court to permit him to withdraw as the attorney of record. Is it uncommon that attorneys withdraw? No, it's not. But it's the language of that notice of withdrawal that, again, caught my attention. In the attorney declaration in support of the motion to withdraw, Anthony Ricco said, quote, on September 22nd, 2024, I was retained by defendant Sean Combs to serve as his counsel, and I have served as his counsel since that time. As a result of being retained, a notice of appearance was filed in court on September 29th, 2024. He then goes on to state his reasons to be relieved. As a result of discussions with lead counsel Mark Agnifilo, this motion for the withdrawal of counsel is filed. While I'm aware that the local rule requires that an application for withdrawal of counsel is supported and granted only upon a showing by affidavit or otherwise satisfactory reasons for withdrawal, there are sufficient reasons related to the protections afforded by the attorney-client privilege for brevity in my application for withdrawal in this case. Although I have provided Sean Combs with the high level of legal representation expected by the court under no circumstances, which is strong language, can I continue to effectively serve as counsel for Sean Combs consistent with the ABA standards for criminal justice? First, I don't think I've ever seen anyone quote the ABA standards, which is an interesting note. Too often when we see these things, there are issues with regarding payment. I don't think that is an issue in this case. It would seem unlikely that payment is the consideration here. And the note about discussions and as a result of discussions with lead counsel Mark Agnifilo, this motion is filed. I think that there are too many chefs in the kitchen, and that if Agnifilo's lead counsel, and it seems that he is, that these two attorneys do not see proceeding in the case the same way. And this attorney alludes to the fact that the ABA standards are requiring him, for ethical reasons, to withdraw based on that disagreement with lead counsel. So I wonder what the nature of the defense here is and the direction that they're going in, where this attorney feels ethically obligated to walk away because of the direction, or I speculate, I should say, because of the direction the defense might want to go in. And we have seen repeatedly that the defense position since the bail motion has been that, at least as to victim one in this case, that the relationship was consensual, that this was not the type of relationship that is being portrayed by the government, and that the government is overreaching and puritanical are some of the things that the defense has said about the government in this case. But I wonder how this will continue to play out as we go forward, and if other defense attorneys will have the same issue with lead counsel, or if this was just between the two of them. So it's interesting to see that it's as a result of discussions with lead counsel, and that this attorney feels that there are ethical considerations. But now it's something I'm going to be keeping an eye on as we get into future filings and arguments in this case. I also think that we will probably see this case get delayed. Or could it be that this is the attorney who wants to delay the case so they can be properly prepared, as required by the ethical rules for an attorney to be prepared for trial? And maybe Agnifilo is like, no, we're going to trial in May. We're pushing it. I wonder if it could be as simple as that. We'll see how this continues to play out, but it's something that I'm going to keep in the back of my mind. And from New York to Idaho, we need to talk a little bit about a case that has been delayed for trial several times, but is supposed to be starting trial in August of this year. And that is the prosecution of Bryan Kohberger for the quadruple homicide in Idaho of 4 students from the University of Idaho. The motions I covered live, or at least the parts of them that were publicly available, on January 23rd and 24th. Remember, those motions were regarding quite a lot of information, but in some, they were motions to suppress for a variety of reasons, including quite a lot of argument based on the use of investigative genetic genealogy, or IGG, and you will hear me refer to it both, well, no, by abbreviation. You'll hear me refer to it by abbreviation. But with regard to that IGG DNA, and the argument was that the FBI had used genetic databases in a way that violated those databases' terms of use, and might have also violated policies within the FBI about accessing those databases to come up with a familial profile of those that might be related to Kohberger to narrow it down. The defense had some difficult arguments here about privacy interest in the DNA profile that was taken from a knife sheath found at the crime scene. And then that DNA profile was used to start to build out a family tree by these databases, because there was nothing, it seems, in the criminal databases when that DNA profile was run. And from there, the FBI narrowed it down, it seems, as a tip that it might be this family, and then ended up in Pennsylvania going through the trash, and then made another DNA profile that then narrowed it down to Bryan Kohberger even further. So the use of that IGG was the crux of a lot of these motions. There were other grounds, of course, but that was one of the large grounds that this was being argued over. And the judge denied all of the motions to suppress. There was also a motion for a Franks hearing, which is a hearing about whether or not law enforcement had been truthful in their affidavits. The court denied the request for a Franks hearing, denied all the motions to suppress, and denied the motions to suppress the IGG. Remember, that IGG data is not going to come up in trial. It was investigative. What's going to come up in trial is the DNA profile from the knife sheath, and then the DNA profile of Bryan Kohberger that was taken subsequent to his arrest. Those are what we will hear about in trial. We will go over Judge Hippler's legal rulings more thoroughly this week. It's just been very busy in court to get to them, but it allows the trial to move forward, and it doesn't suppress any of the evidence that was recovered not only from identifying Kohberger, but from his devices, his Amazon account, his Apple accounts, his iCloud accounts. All of those technology search warrants were also upheld. And to the one case that's not supposed to go to trial this year, Blake Lively, Justin Baldoni, Wayfarer, and all of the lawyers. So as was requested by the court, Lively's team filed their first amended complaint by the deadline, their FAQ, as I call it, and they definitely leaned into the dramatic writing of a legal complaint. Their earlier complaints had not been nearly as loquacious as this one was, leaning into argumentation more heavily than their prior filings, quoting Justin Baldoni's TED Talk at the very beginning of their filing and laying out more arguments and details than we had seen previously. Remember that when Baldoni made his filings, the Lively complaint had already been filed and the CRD complaint had already been filed. So we didn't see any conversation from Lively's side in their complaints regarding the takeover of the movie or anything like that. That hadn't been alleged yet. So this complaint reads half like a complaint, half like a PR statement, half like an answer to the lawsuit. Emily, that's too many halves. It is. It's all of it. We also saw new attachments that hadn't been in the previous complaints, emails included, other text messages included, and some of the same text message. We also saw more argument that there had been other HR complaints and more conversations in real time with Lively talking about what was going on set from her perspective. Two things to note before we do a deep dive on this, which we have not had a chance to do yet, is that one, there's a text message that I found very interesting, legally speaking, because yes, this first amended complaint adds additional causes of action. It also adds Jed Wallace, who is suing Lively in Texas. I imagine we'll see filings in Texas to try to remove the Texas cause of action into New York with this cause of action. Emily, are we going to get into federal removal? Maybe. There's going to be a lot of litigation no matter what, but I think we will see filings in Texas because of this filing, also bringing Jed Wallace into the lawsuit in New York. Though once you get through all of the bluster in this complaint, which in all of these complaints has gotten to levels heretofore unseen. But again, this is going to be the nature going forward of high profile litigation. It is written for both the court of public opinion and the court. And remember, at the heart of Lively's complaint is still an employment litigation. The laws in California, which are what's being filed here in New York, that is a whole different discussion for another day. Yes, you can do that. We will see if that gets litigated by the other side. But for now, the laws in California are what they are litigating over. I imagine some of the contracts involved here say maybe that the laws of California abide, but maybe not where jurisdiction is for the courts, but we'll see down the road. But those California employment laws, if there are complaints made of harassment, then the retaliation claims, the duty to investigate, and some of those other claims become much easier to prove. The threshold on those are pretty low, whether or not harassment is ultimately proven. If it is complained of, then there are things that the law in California requires to be done. And we see some of that in this litigation where it seems that Wayfarer is trying to make up for some of those deficiencies. Because again, whether or not harassment is found, there are obligations based on a complaint being made because we are dealing with an employment law litigation. So we see two things that's interesting in this first amended complaint. We saw this text message referenced in the first filing in federal court by Lively and discussed. As we get to the attachment that's new in this, I think the text is relevant as to whether or not HR complaints were made. There's been a lot of discussion about if HR complaints were made. And it seems based on this August 14th, 2024 message between the Wayfarer parties PR team, Melissa Nathan and Jennifer Abel, that they are discussing whether or not there are or were HR complaints. And it says, hey guys, regarding the TMZ thing, regarding, they use RE, but regarding the HR complaints, our understanding is that 2 were from Blake and blank, the name's redacted, regarding the quote unquote sexy comment, which we see referenced elsewhere in the complaint, is the additional one from name redacted regarding the thing with Jamie and her apartment in New York City. Just want to clarify. So it seems that there are 3 potential HR complaints. Why does that matter? Look, if the complaints are made, it makes some of the causes of action much easier to prove, again, whether or not the harassment is ultimately proven. Will that matter in the court of public opinion down the road? Unlikely. Does it matter, legally speaking, for the position of this case? If each side has causes of action that are strong, it is more likely that A, this case can move to resolve at some point down the road, or B, it's going to be split however you see it because of those California causes of action. But if this ever sees a jury, because there are so many causes of action, it's going to get incredibly confusing regarding the defamation, the retaliation, the intentional infliction of emotional distress, who did what to whom, whether there were or were not HR complaints. And this goes from a employment law case to something much bigger because of how many causes of action there are, and now how many different parties there are. Even when you look at the header of this lawsuit, it is already a bit unruly because it is Lively versus Wayfarer Studios, Justin Baldoni, Jamie Heath, Steve Sarowitz, It Ends With Us Movie LLC, Melissa Nathan, The Agency Group LLC, Jennifer Abel, Jed Wallace, Street Relations. But then you also have the consolidated complaint, which is a lot of those parties, less Jed Wallace and his company, versus Lively, Reynolds, Leslie Sloan's Business, and the New York Times. So you've now ended up with quite a lot of parties involved. And by the time, if this ever goes to a jury trial, it's going to be half of a courtroom of tables of attorneys and clients. And why I brought up the employment litigation of it all in this is because there is a new attachment that had an interesting footnote that I think is going to continue to fan the flames of this Lively doesn't want to be deposed by Brian Friedman situation, that we saw the attorneys for the Wayfarer parties note that in a meet and confer call, Lively had said, I'm not being deposed by him. And they brought it to the court's attention and the public's attention, saying a party can't pick who deposes them. Well, it's in this letter as well. This is attachment number 5 in the first amended complaint. It is a letter from February 14th from the attorneys for the Lively parties to a law firm and a company called Adam Investigations Counsel. And this letter seems to be referencing back to a newly begun investigation of harassment claims. It says, quote, on behalf of our client, Blake Lively, I write to respond to your letter of January 31st, 2025, and to follow up on our conversation of February 12th, 2025. In your letter, you state that Wayfarer Studios LLC has retained your firm, quote, to conduct a neutral third-party investigation of Blake Lively's complaint for sexual harassment, retaliation, failure to investigate, prevent, and or remedy harassment, and aiding and abetting harassment. You asked to interview Ms. Lively to fulfill Wayfair's legal quote-unquote mandate to investigate. It goes on to say, with respect, we find this years too late request baffling and must decline. Well, litigation has already commenced, so the shit's out of the horse on the company duty to investigate, because that is triggered when the complaints are made. Goes on to say, as you note in your letter and confirmed in our call, employers have a legal mandate to investigate complaints of harassment. It goes on to say, however, the law mandates not just an investigation, but one that is prompt, thorough, and effective. Wayfarer's proposed investigation is clearly none of these. It's interesting to me that the investigation seems to be getting undertaken now. I think this will be a point of contention going forward because they're going to say, look, we tried to investigate, but we didn't. But the law in California is pretty strict with regard to what employers are required to do. The letter goes on to say, first, the fact that your firm has only been retained now, nearly 2 years after Ms. Lively first raised her harassment complaints in May 2023, makes a mockery of the law's requirement of prompt investigation. It's interesting to me that we are seeing that the complaints were made in May 2023. We've seen that outlined elsewhere. I'm interested to see where those complaints were made to, how they were documented. And as I've said, with all of this litigation, this is a movie set. There are multiple companies involved and lots of people involved. I imagine everything is documented. And if it is not, and this goes to jury trial, the lack of documentation will be quite loud and I think telling, because in cases where all sides are saying, but they say it's this way, the jury tends to look to those contemporaneous things. What were people saying at the time? What did the emails say? What are the companies saying? And who was told and when? At the end, they say Wayfair and its counsel, footnote 1, have spent the past few months in the press calling Miss Lively a liar, stating there was never any retaliation and claiming that she invented her claims of sexual harassment out of a malicious intent to harm them. Indeed, just a few weeks before you sent this letter, Wayfair and its principals filed a 9-figure lawsuit against Miss Lively and her husband, asserting that the very claims Wayfair now would have you investigate are false, defamatory, and even extortionate. Moreover, from the moment they understood that Miss Lively complained, Miss Lively has alleged that Wayfair and its principals have been on a stated mission to quote-unquote bury and quote-unquote destroy her and those who defend her. The footnote 1 goes directly to what Wayfair said in its other filings, and I imagine has been brought up more than once, saying, quote, on the issue of Wayfair's counsel, you stated that any represented party would be permitted to have counsel present during their interviews with you. We note that all of the material Wayfair party witnesses are represented by Brian Friedman, who have repeatedly publicly attacked Miss Lively as a liar, including but not limited to calling her heinously selfish, and has scoffed at her sexual harassment claims, saying they, quote, exploit actual victims of real harassment and are, quote unquote, completely false, outrageous, and intentionally scandalous. No interview in which Mr. Friedman is present could be neutral. So even as of this February 14th letter, it persists that they do not seem to want Brian Friedman involved at all. And I don't think this is the end that we're going to see there. In other filings, the PR agent Leslie Sloan filed an extensive motion to dismiss and anti-SLAPP motion that we will look at more thoroughly. But of note is some of the things I pointed out when I first looked at the Baldoni suit was the Baldoni suit and the first amended complaint do not delineate which plaintiff vis-a-vis which defendant. And that is a substantial part of the Leslie Sloan motion, saying the defamation claim, for instance, is all parties against all parties, but it never lines out anything Leslie Sloan specifically said. So there are some filing issues because of the way it's pled that might get narrowed down in the Baldoni complaint to say which cause of action specifically go to which defendant. If the anti-SLAPP is granted to any counts, then those counts would be gone. If the motion to dismiss is granted, then there's generally an opportunity to amend the complaint to make it more clear. I wonder if we will see similar filings by the New York Times. I also wonder if we will see another amended complaint to state which causes of action go to which plaintiffs and which defendants, which was not done in the first filings. We will see. But we will look at that motion to dismiss and anti-SLAPP and see how well taken the other substantive portions are. But of note to me is those really broad filings, and I think we will see that get tailored down. But when I said at the beginning of the year that one of the things I had hoped to have more time for in 2025 was reading, the things I meant were not hundreds and hundreds and hundreds of pages of litigation. It is quite a lot to not only digest, but break down and juxtapose, which is what I'm hoping to do with all of the filings we have, to bring you overviews of them and sometimes deep dives of them and point out where the legally significant parts are, where maybe the legally shady parts are, and then where the ridiculousness is, because a lot of these filings have so much argumentation in them. At some point, the federal judge is going to say this level of hyperbole is unhelpful. Can we please all just take a step down? But in the First Amendment complaints, I'm not really surprised that we saw the Lively attorneys take a complete turn in the way they were filing the pleadings, because that is what is happening in this case. Is it what we see in most cases? No. Is it a concise statement of the complained of actions? No. It is adding more than 50 pages, and not all of that goes to Jed Wallace. A lot of that also goes to the defense theory. So when I said part PR, part answer, part complaint, it's all of those things. And it's a lot. So let me know what stories you are following along with most. and what we need to deep dive first, because there is so much happening. It's going to keep us incredibly busy. But for now, I will see you in court on Tuesday, February 25th. And we've got other court dates coming up this week too. And if you don't want to miss court, or at least court when we start it on EDB Standard Time, make sure you have the Law Nerd app at lawnerd.app.com so that you never miss a moment of the cases that you care about most, or our next merch drop. But my Law Nerds Rock Head is still in the Law Nerd shop, though almost everything else from our last merch drop is gone. So go check it out if you like. Otherwise, I will see you in the app. I will see you on stream. Thank you for being here. Thank you for being a Law Nerd, and may the odds be ever in your favor. I'll see you in the next one. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerd.app.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.